without further ado, I'm going to introduce Ashley Harrington and Katie Glynn. Ashley Harrington is the managing attorney of the Remains Children's Program and my boss. She is an expert in SIJS, and Katie Glynn is a former managing attorney of Remains Children's Program, and she is now an attorney at Grob and Eirich doing family law cases as well. So I will pass it on to them and let them get to the meat of it. So thank you.
Thank you guys so much. I just want to echo what everyone else has already said, that we are absolutely overwhelmed by how many volunteers are here and the support from the community of lawyers that want to help out these children and families. I really, truly do not think it's an overstatement to say that this work is life-saving work, and that getting involved in one of these children's cases or families' cases truly can help to save their lives. So we really, really thank you for being here and for your commitment to helping these children and families. So let me just give you a brief overview of what Katie and I are going to cover. I'm going to give you a really quick and dirty overview of the law on special immigrant juvenile status, or SIJS. Katie's going to take you through in depth the first step in that process of special immigrant juvenile status, which is representing the family or child in state court proceedings. And then I'm going to take you through the immigration piece, sort of the second piece of the case of applying for special immigrant juvenile status and permanent residency, as well as throughout the case representing your client in immigration court proceedings. I want to give a quick caveat and just let you know our slides are very text heavy. They're not very visually interesting or beautiful slides at all. We have packed in a ton of information, way more information than we're going to cover today, and certainly more information. We're not going to stand up here and read them to you, but I'm hopeful that our PowerPoint will be sort of a reference guide for you once you get your case, or before, if you want to be super prepared and be an overachiever before you get your case, or once you have it, really to be a reference guide to go through. Okay, what was that law that they talked about? What is this procedure that I'm going through? Where do I find the policy manual, etc.? That will all be here for you in the PowerPoint, as well as Alex will send you all out a very detailed referral memorandum on each case that you take, whether it's just the state court piece, or just the immigration piece, or the full piece, or also an asylum claim, whatever it is. We'll have a full referral memoranda for you. That'll also walk you through a lot of it. So, okay, brief overview of the law. What is special immigrant juvenile status? What is the purpose of it? It is a pathway towards lawful permanent residency and eventual citizenship for children that have been abused, neglected, or abandoned. So Eirich, at the end of his intro this morning, showed you that pyramid of different kinds of immigration statuses. Special immigrant juvenile statuses is one way to sort of move people from being undocumented along the continuum, or up the pyramid, if you will, towards eventual lawful permanent residence and U.S. citizenship. One really important note about special immigrant juvenile status is that it is only for the child. There are lots of other pathways towards status that you can bring along a parent, or you can bring along a child, or bring along a sibling, or something like that. Special immigrant juvenile status is really a pathway solely for the child. Even once they become a U.S. citizen at the end of this whole process, they can never petition for or apply for permanent residency or status for any parent. The background on special immigrant juvenile status, it's something that's been in place in our law since 1990, but in a very limited form. It was only for children who were already in or were eligible for long-term foster care in its original form. And then it was significantly expanded by the Trafficking Victims Protection Reauthorization Act, which Christine talked about some today. The TVPRA did a lot of great things for children, allowing them to submit their asylum applications with USCIS, even when they're in removal proceedings, exempting unaccompanied minors from that 1-year filing deadline of asylum, changing custody conditions for children when they first cross the border, and who detains them or who takes care of them, all kinds of protections for children under that law. One thing that law did is significantly expand who is eligible for special immigrant juvenile status. And we'll talk in just a minute more about the eligibility requirements now under the current law of 2008. It's a really unique area of the law. Special immigrant juvenile status is the only area of the law that I know of that requires the participation of state courts, state court judges, and immigration authorities in order to grant a child immigration status. There are lots of other forms of immigration status where it's just immigration officers who are making a decision about, was this person a victim of crime or was this person abused, and then granting somebody lawful status based on that determination. Special immigrant juvenile status leaves those determinations about abuse, abandonment, neglect, best interests of children, and stuff like that to a state court and to a state court judge rather than to the immigration officers. And so what that state court is doing is making several special findings of fact in what we call an SIJS order, a predicate order, a state court order. You'll hear us use those terms interchangeably. They all mean the same thing, that a state court is making that initial order to allow the child to then move on and apply for special immigrant juvenile status. Here is where you'll find the law. This is the statute under the Immigration and Nationality Act, the Code of Federal Regulations. The current version at 204.11 is very outdated and it doesn't reflect the amendments from 2008. So we have proposed regulations that came out in 2011. We are still waiting now in 2017 for those to be finalized, but you'll want to look at both those old regulations and the proposed regulations. And then we have a relatively recent policy manual from USCIS from October of 2016 stating what USCIS's policy is on adjudicating these kinds of cases. That policy manual supersedes all but one previous memoranda on SIJS, so it's really the place you want to go when you're looking for USCIS policy. Here's the definition. Don't worry, I'm not going to read it to you. It's very long, but there's the definition in the statute. Breaking it down, the core requirements to be eligible for special immigrant juvenile status is that a child must be present in the U.S. This is not a status like other things where you can apply from outside of the United States. You must be here physically present throughout the case in order to apply. The child must be under 21 years of age and unmarried. That's the definition of child under the Immigration and Nationality Act. We already had one question comes in, what if your child turns 18 or turns 21 while the case is pending? There are age out protections so long as the petition is filed before the child turns 21 and remains unmarried, they will be protected. Again, the one major requirement is that the juvenile or state court must enter this SIJS order, or this predicate order with the certain factual findings that we'll go into in a lot of detail. What's a juvenile court? It doesn't have to be, in Colorado, I believe we only have one court that's actually called a juvenile court, the Denver Juvenile Court. It doesn't mean that Denver Juvenile Court is the only one that can issue this order. It doesn't matter really what the court is titled. It matters, is it a court located here in the U.S. that has jurisdiction under state law to make judicial decisions about the care and custody of juveniles? Does this judge have jurisdiction to make decisions about care and custody of juveniles? If so, it equals a juvenile court. And then the last requirement is that the Department of Homeland Security through U.S. Citizenship and Immigration Services must consent. The way that they have interpreted their consent authority is basically they want to know that this is a bona fide petition. What that means is that you were not going into court with the sole only purpose to get that SIJS order. There's another valid basis why this kid needs a legal guardian in the U.S., right? Why this mom needs a custody order over her child, or in other contexts, why a dependency and neglect order was sought or a delinquency order was issued, things like that in other contexts. But in the context that we're going to focus on with you all, that there is another valid basis for going into court in the first place to seek a custody order or a guardianship order. The 4 findings that must be contained in your order are that the child has been declared dependent on the court or has been legally committed by the court to an agency, department, or individual. So in your cases, in allocation of parental responsibilities or custody, is we call custody in Colorado this ridiculous thing, allocation of parental responsibilities, or APR means custody. Your court has placed the child in the custody of an individual, in the custody of their mom, in the custody of dad, in the custody of older brother, uncle, aunt, whoever it is, or in the custody of their guardian. That reunification of that child with one or both of their parents is not viable due to abuse, neglect, abandonment, or a similar basis under state law. So this child by one or both parents has been subjected to abuse, neglect, or abandonment, and reunifying or living again with that parent is not viable because of that abuse, neglect, or abandonment. That it's not in the child's best interest to be returned to their country of origin, and that the court has jurisdiction and will maintain jurisdiction over the child. So Katie's going to take you through in much more detail each of these factual findings in the different state court proceedings that you'll find yourself in, but these are the core requirements that you need to have in your order. For each of these, you cannot have an order anymore that just has this language. You have to have specific facts for your case. So here, this child has been placed in the custody of their uncle, Mr. So-and-so. Number two, reunification of this child with dad is not viable because he was abusive. He was physically abusive in this way, details about your particular client's case. It doesn't need to be paragraph upon paragraph of, a full declaration or anything, but it does have to have specific facts. You can't just have the statutory language there. And same thing with the best interest. Why in your client's particular case is it not in their best interest to go home? And I'll turn it over to Katie.